Hello, good morning to everyone. So today's this short clip or this short class, we are going to be discussing about the supplement that have been received like yesterday or day before yesterday, basically before 4 or 5 days before your exam here. So it is a very short and sweet compilation, and we have already discussed in our live lectures also, in our classroom programs also. But just to make sure that all the children are at peace, we are going to be discussing it once more here. So basically, when it comes to this, the important aspect here is there are some cases, and the most important part is as per the IT law, the new guidelines introduced in 2025 that are going to be asked there. So I asked children to look at the bright side that they have given us what they are going to be asking for. At least 5 marks is going to come from these 10 pages only. So we doesn't need to create panic, rather we just need to keep our head focused. So first, there is a case relating to the law of evidence, or we call it BSA, Bharati Sakshi Adhiniyam. Amlesh Kumar versus State of Bihar. The Honorable Supreme Court held that accused person has a right to voluntarily undergo a narco analysis test, but appropriate stage of the trial. That is when the accused is exercising his right to lead the evidence. So, having said that, there is no indefensible right of the accused to undergo a narco test, as the right is dependent on many factors to be considered by the court concerned. So, basically, this case talks about Article 20 clause 3 also, and we can connect the sale case of Selvi versus state of Karnataka also, which was asked in previous years also. So this is actually nothing but Supreme Court saying that you cannot ask for narco analysis whenever you want. There is a time for everything, and there are many factors which are to be considered there. So if you talk about Article 20 clause 3, you can mention this case there. Then next we have law relating to limitation. See, the case of Jharkhand versus Bharat Heavy Electric Limited, Supreme Court held that limitation period for filing appeal under Commercial Court Act 2015 commences from date of pronouncement of judgment, and that party cannot insist that limitation start only from date of receiving a copy of judgment. We have discussed this also. So we know, as per section number 12 of Limitation Act, we know that the period of limitation commences from the day the judgment is received, and that time is excluded which court takes to give the copy. But we need to file an application for that also. So petitioner was aggrieved by High Court refusal to delay in filing commercial appeal. The petitioner argued that limitation period should commence only after receiving a copy. The court clarified that Order 20, Rule 1 of CPC, place a duty on court to provide a copy of judgment. The litigant is nonetheless expected to make reasonable effort for applying it, making the application there. Then only your limitation period will be stopped there. So the appeal was dismissed. Then we have law relating to arbitration, mediation, and conciliation. In Genclore International versus Sri Ganesh Metal and another, Supreme Court observed that the non-signing of an arbitration agreement is no bar to refer the dispute to arbitration if parties have otherwise consented to the arbitration. We know that arbitration is nothing but depends upon the consent of both the parties or the court there. So if the party had not signed initially any kind of arbitration agreement, but later they decided that they are going to, that is none of the barrier there, they can go for arbitration there. Then we have IT Act amendment here. So what we need to do is we need to make it brick by brick here. We need to sort it out. So see, the first thing that they are giving is update on law of personal data protection, which we have covered in our live class also. They have given it in their momentum there. So Digital Personal Data Protection Act got the assent of President on India on 11th August. The law declares full framework for protection of digital personal data in India. Purpose of law: provide the law relating to processing of digital personal data in manner that recognizes both the right of individual to protect their personal data and need to process such personal data for lawful purposes thereto. So we need to understand section number 79 and section number 43A here. So when it comes to 49, we know that it talks about the intermediaries. It has come from the case of Google versus Vishaka Industries. So the act follow the SARL approach. This means simple, accessible, rational and actionable. This paragraph is important here. Further, Government of India also notified Digital Personal Data Protection Rule 2025 on 14th of November. This marks the operational of Digital Personal Data Protection Act 2023. Together, the Act and the rule form a clear and citizen-centered framework for responsible use of digital personal data. So, what does it do? Following the notification, the digital personal data is being implemented in 3 phases. You have to know this. And 18-month rollout. The DPDP rule provides an 18-month phase compliance timeline, allowing organization time for smooth transition. They also require data fiduciaries to issue standalone, clear, and simple consent notices. Then, immediate effect. Phase 1, we are talking about phase 1 here. The phase focuses on institutional and foundational legal work. Key provisions are now actively included in establishment of data protection board. So that is it for the phase 1. They are going to find institution, they are going to implement these schemes in the government institutions there. Then after 1 year, there will be phase 2, which will be beginning from November 12, 2026. The intermediate phase is dedicated to the consent manager ecosystem. This part is important here. Provision relating to registration and obligation of consent managers will come into force, allowing the entities time to meet the standards of DPBI. Then phase 3 will begin after 18 months, which will be on 2027 May of 12th. So the final phase would activate the majority of core operational compliance for all data fiduciaries. This is the time limit for business to implement changes across their system. Key requirement includes mandatory notice and consent mechanism, implementation security safeguard, processing personal data of children with verifiable parental consent, establishing system for data principal right and adhering to data retention and automated erasures requirement. See, what we see from the exam perspective, that we need to learn these phases. We need to learn a little bit of introduction relating to 2023 and 2025 rules and the act itself, and the question will come, it will be based on the phases only. And then there is the definition part here, which includes the definition of the board, data principle. The data principle definition is important there. So because it includes a child whose parents are also included, a person with disability, data processor, personal data breach, all these definition need to be learned. So we have 5 newly added definition in the IT Act. That is not at all a big deal to be dealt with. So no tension. We have already discussed data fiduciary in the 2023 Act only in the live class there. So then we have application of the Act. The Act will apply to the processing of digital personal data within territory of India, wherever data is collected in digital form or non-digital form, and also apply to processing of digital personal data outside the territory of India, if such processing is in connection with any activity related to the goods or services to data principle within the territory of India. So it will apply to India whether your data is taken digitally or it is taken non-digitally, and it will apply to outside India also when it is processing Indian data. So now we need to see where it does not apply. So personal data which is processed by an individual for personal or domestic purpose, personal data that is made or caused to be made publicly available by data principal to whom such data relates, or any other person under obligation for time being in force to make such data available in public. Then rule 4 introduces a phased compliance schedule extending up to 18 months. We have discussed it from the date of notification. Rule 12 provides operational clarity for exempted categories by requiring data fiduciary to maintain limited logo even in respect of data category. So basically, in this, we need a brief intro relating to the 2023 plus 2025 guidelines. Then we need to know about the phases from 1 to 3. Then we have almost 5 important definitions that we need to look. Then we have rule 12 with us and section number 3 related to the application with us. So that is it for the IT Act amendment, and we just need it once. Then we have law relating to negotiable instrument. You can read it once and it will be done there. So that is it for the supplemental portion part. There is nothing to worry about, and best of luck for your exam. Keep your head the game, keep your focus, and again, best of luck. We will be seeing you very, very soon. All my best wishes are with you from my side and for as well for the institution as well.